see the response?
I would have served it on you back on.
I
Yeah,
might have had it in my email.
it's been a little
It's
bit.
been a while, yeah, because I filed the motion a while ago.
December 17th is
Okay.
my certificate of service.
All right, so are you Jonah Johnson?
Yes, ma'am.
And Mr. Johnson is charged in cause number 25 DCCR 1775 with aggravated assault with a deadly weapon. And Ms. Holmes has filed a motion asking that Mr. Johnson's bond be reduced. It's currently set at $300,000. And then there's also 2 misdemeanors that he has as well. And those bonds, it looks like, are $3,000 and $5,000, which we're not discussing, but just that he has the charges also, in addition to aggravated assault with a deadly weapon, to misdemeanor charge of unlawful carrying a weapon, 2 cases of unlawful carrying a weapon. And so Mr. Coleman filed a response, obviously in opposition to that. Ms. Holmes, Mr. Johnson, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. You may proceed, Ms. Holmes.
Thank you. Mr. Johnson, how long have you been incarcerated at Jefferson County Jail?
2 months.
Okay, and in that 2 month span, your bond has been set at $300,000, is that correct?
Yes, ma'am.
And has your family tried their best to secure or try to get you bonded out at that amount, have been unsuccessful?
Yes, ma'am.
Okay, now, prior to this, was your bond originally at a different amount, and was it raised at some point?
Yes, ma'am.
Okay, and do you have any property or anything that you could possibly sell to secure where the current bond amount is?
No.
Okay, does your family have any type of assets or property that could secure it at this amount?
No.
Okay, are you requesting that the judge lower the bond to give you an opportunity to bond out, and whatever stipulations the court may have, whether it's a GPS tracker or home confinement, would you be willing to abide by those restrictions?
Yes, ma'am.
And where would you be residing if you were able to bond out?
I'm on the side.
Okay, and where is that in Beaumont?
Yes, ma'am.
Okay, and your mom is here today, correct?
Yes, ma'am.
Okay, and she would be able to let the judge know that that's where you would be residing?
Yes, ma'am.
Okay, and since you've been incarcerated at the Jefferson County Jail, have you received any write-ups?
No.
Okay. At this time, I'll pass the witness, Your Honor.
I have no questions for the defendant, Judge. Just argument, please.
Okay, so I would, just for the record, I'm taking judicial notice of the court's file. It does include an affidavit of surety surrender. That's where the bond got increased, because the bond's been filed. That affidavit, because it reads that the defendant failed to pay for his GPS device. It had not been charged at that point. So this, it says since 11/7 of 25, and this was filed November 19th, so it hadn't been charged for a couple of weeks, it looks like. They further stated that he will not respond to their attempt to reach him, and he cannot be located. Therefore, they felt like their bond was at risk, and that's why they filed that affidavit to get off the bond, which was granted, and that's why that was raised. Give me just a second. I also want to take a look at the probable cause affidavit, just so that I can have an idea of what we're talking about.
When you're
Mr.
done with
Hall?
that probable cause affidavit, I'd like to offer, for the limited purposes of this hearing, the surveillance video from the apartment complex of the incident.
Okay, thank you. Any objection for this hearing?
No objection.
I'll take a look at it. Give me just a second when I take a look at this. Mr. Coleman, I'm ready.
partially with the video, I just want to highlight in my reply, the defendant Scott, he has 9 prior arrests, 2 of which were for unlawfully carrying a weapon. Those cases were pending when he committed the instant offense. Judge, the video, I'll just summarize by saying it's like a Wild West shootout in broad daylight in the apartment complex. Here's the video there. You can just hit play there. Of course.
Has, and what about Kendrick O'Veal? Is he charged as well?
I don't think he got charged.
He was the other shooter, according to
he would be
the
the person in the video there in the front. They're saying at the front of that red truck. My understanding is that it's the defendant here who's in the background wearing the dark cluttered clothing.
Okay.
And the bystander who is shot, you'll see her behind like that white van.
Okay.
Because I think the young lady got charged with tampering. I think the one that got shot got charged with tampering. O-V-E-A.
In that video, it also appears that the first shot, and it's obviously not the best angle, but anyway. The motion's denied. You can go back with the bailiff. It's crazy. Insane. Nope, you need to go back with the bailiff. Good morning, are you Deontay Reed?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
It will, Your Honor.
Mr. Reed, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Speak up, please.
Yes, ma'am.
All right, thank you. You can put your hand down. Mr. Reed, in cause number 24, DCCR 0838, I have a motion to revoke your community supervision. Shows that you were placed on probation July 15th of 2025 for the state jail felony offense of theft of a firearm. And that was a 2-year term in prison that was probated for 5 years. Is that correct? Speak up. Is that correct? Yes or no? Okay. Then it alleges that you violated your probation. It alleges in count 1 that you failed to report as directed July 18th of 2025. Is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 3 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? And then finally, count 4 alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And because you actually did those things or violated your probation? All right, I'm going to find counts 1 through 4 true, find that you entered those pleas freely and voluntarily, find sufficient evidence to revoke your probation, but it sounds like there's an agreement. Is that correct?
Yes, Your Honor.
Yes, Judge.
Mr. Coleman, what is that?
Your Honor, the court would ask that the state would ask that the court sanction this defendant with 60 days in jail and then thereafter continue him on community supervision.
And is the intention that he receive credit for any of the time since he's been in jail on the MTRP?
Can you get credit for
Yeah.
as a
That,
condition?
Yeah,
Okay.
yeah, just from the time that, the only time I would do it is from the time he was arrested on the MTRP, not the
Right.
prior credit.
State's not supposed to give him credit.
Okay, so then, Mr. Reed, it sounds like the state and probation's willing to work with you, and I want to make sure you understand this opportunity that you're being given if I go along with it. if I go along with this, you'll get the 60-day sanction. You're going to be right back out on probation. The first thing you have to do is report to probation. You will not get this opportunity again. If you don't report, if you don't do the classes and the community service and everything you're supposed to, you're going to end up getting that 2-year sentence that you've already agreed to. Do you understand? All right. So I'm going to sanction you, continue your probation, sanction you 60 days. You will get credit for the time since you've been arrested on this charge, on the motion. And then as soon as you're done again, you'll go straight to probation. Okay? All right. Good luck to you. Take advantage of this opportunity.
He has.
Morning, sir. You're Forrest Mabry. And Ms. Holmes, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Give me just a second. Mr. Mabry, in cause number 25, DCCR 0580, let's see, are we going on? Okay, more
On
than
the first one, because I think.
We can
this
do paragraphs 1 and 3, Your Honor.
Yes.
1 and 3?
Additional paragraph on that.
the state is proceeding on paragraphs 1 and 3. Count 1 alleges that you committed the third-degree felony offense of stalking on April 7th of 2025. That indictment alleges that you were previously convicted of, gosh, I can't read this. It's
Improper use of equipment.
the felony, third-degree felony offense of improper use of equipment from September 27th of 2007. And how do you plead to that charge? And is that prior conviction true?
Yes, ma'am.
And did you enter your plea of guilty and true freely and voluntarily? All right, give me just a second.
Chapter 2 of them.
I don't know why some of the indictments, some of the things to get scanned in look so crazy. I can't read it.
Do you need mine, Your Honor? Do you want to use mine?
No, it's fine. I can print them out and they look fine. I was able to get it done. Let's see. All right, sir, in cause number 25, DCCR 1069, you're charged with the state jail felony offense of credit debit card abuse, and that's from March 26th of 2025. And then in this case, what are we going on?
The indictment is count 1 and then 2 and 3.
2 and 3?
Gets us to,
Count 2 alleges that you were previously convicted of improper use of equipment, a third-degree felony, September 27th of 2007. After that was final, you were convicted of possession of methamphetamine in a drug-free zone, a second-degree felony, December 18th of 2009. And how do you plead to that charge? And are those prior convictions true? Did you enter your plea of guilty in that case also, and true, freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them?
yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. Mabry is not competent?
No, Your Honor.
All right, Mr. Mabry, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 25 DCCR 0580, find sufficient evidence to find you guilty, and at this time find you guilty of stalking. Find the prior conviction true. Sentence you in accordance with your agreement to a term of 14 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 25 DCCR 1069, also find that you entered your plea of guilty and true, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 14 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
And there it is, a courtroom moment that reveals more than just facts. It exposes patterns. A man asking for a second chance, yet a past filled with missed responsibilities, unanswered calls, and rising risks. The judge didn't just hear words. She saw behavior. The video, the history, the silence when it mattered most, it all painted a picture no argument could erase. And while one decision closed a door, another case showed how quickly leniency can turn into consequence. In the end, the question remains, how many chances are enough before accountability becomes unavoidable?